អង្គុយចុះអង្គជំរះប្រកាសបន្តកិច្ចដំណើរការនីតិវិធីសកម្មការនៅថ្ងៃនេះអង្គជំរះនឹងធ្វើសកម្មការស្ដាប់សក្ខីកម្មសាក្សីដែលមានរដ្ឋនាមពី TTW 900 ពាក់ព័ន្ធជាមួយនឹងអង្គហេតុចោតប្រកាន់មន្ទីរសន្តិសុខអូកន្សែងដោយធ្វើតាមរយៈប្រព័ន្ធសោតទស្សន៍
via a video link. Is there a technical issue with the interpretation? Please check.
We didn't have a translation of the first part.
The court is now in session. Today, the chamber will hear testimony of a witness, that is through TCW 900, in relation to O Consign Security Center via a video link. There is a video link from this chamber to the witness who is in Udor Meanchey province. Mr. M. Hoy, please report the attendance of the parties and other individuals to today's proceedings. Grefye, Mr. President, for today's proceedings, all parties to this case are present, except Madame Touvolet, the standby counsel for the accused, who will be a little bit late. Mr. Nunchi is present in the holding cell downstairs. He has waived his rights to be present in the courtroom. The waiver has been delivered to the greffier. A witness who is to testify today, that is through TCW 900, will testify from Onlongwe District, Udor Meanchey Province. The witness confirms that through his best knowledge, he has no relationship by blood or by law to any other two accused, that is Nunchi and Kir Sampon, or to any of the civil parties admitted in this case. The witness took an oath already, and he has Momrati as a duty counsel. And the AV unit personnel informs the chamber that the video link setup has been done, and the witness is ready to testify via a video link. Thank you. President, thank you, Mr. M. Hoy. The chamber now decides on the request by Nguyen Chia. The chamber has received a waiver from Nguyen Chia, dated 21st March 2016, which states that due to his health, that is headache, back pain, he cannot sit or concentrate for long, and in order to effectively participate in future hearings, he requests to waive his rights to be present at the 21st March 2016 hearing. He advises that his counsel advised him about the consequence of this waiver, that in no way it can be construed as a waiver of his rights to be tried fairly or to challenge evidence presented to or omitted by this court at any time during this trial. Having seen the medical report of Nguyen Chia by the duty doctor for the accused at the ECCC, dated 21st March 2016, which notes that Nguyen Chia has a chronic back pain and feels dizzy when he sits for long, and recommends that the chamber shall grant him his request so that he can follow the proceedings remotely from the holding cell downstairs. Based on the above information and pursuant to Rule 81.5 of the ECCC internal rules, The Chamber grants Nuchi his request to follow today's proceedings remotely from the holding cell downstairs via an audio-visual means. The Chamber instructs the AV unit personnel to link the proceedings to the room downstairs so that Nuchi can follow. That applies for the whole day. And before we proceed to hear testimony of a witness through TCW 900 via a video link, the Chamber will issue an oral ruling on the request by the International Co-Prosecutor in relation to questioning this witness. And second, the Chamber will hear responses from parties through the submission by the co-prosecutor to hear two additional witnesses in relation to Phnom Krom Security Center. The Chamber now issues an oral ruling in relation to the International Co-Prosecutor's request, that is document E319/23.3.5. The trial chamber is seized of E319/36, the International Co-Prosecutor's request to admit 95 additional written records of interview. This request includes a written record of interview of through TCW 900, that is today's witness, and please refer to page 48 of document E319/36.2. Considering the potential usefulness of this document to today's proceedings, the trial chamber hereby makes a partial ruling and admits through TCW's 900 a written record of interview, that is document E319/23.3.5, into evidence, and assigns it document number E3/9734. Written reasons for this ruling and on the remaining request of E319/36 will follow in due course.
បើជាបន្តទៅនេះអង្គជំរះ
The Chamber will now hear responses from parties to the request by the co-prosecutor to hear additional witnesses in relation to Phnom Krom Security Center, that is document E390. On 16 March 2016, co-prosecutors filed a submission to the trial chamber to call two additional witnesses, namely through TCCP 1016 and through TCW 1017, to replace some witnesses who are now deceased in relation to Phnom Krom Security Center. For that reason, the Chamber intends to hear oral responses by parties in relation to this submission, so that the Chamber can use it as a basis for our decision whether to hear these two additional witnesses or not. And I'd like to first hand the floor to the co-prosecutor to reiterate their submission that they filed on 16 March 2016. You may proceed.
Thank you, Mr. President. Good morning, Your Honors, Counsel. I'll be fairly brief. We filed this motion out of concern for an obvious reason. Last month, when the witnesses were announced for this segment, the trial chamber and the parties were informed by WESO that 3 of the 6 witnesses that had been proposed for the segment by the co-prosecutors had been determined to be deceased. So we started a process of going back and reviewing from scratch the the available witnesses for this segment. A number of other people who were potential substitutes are also, it turns out, deceased. We think it's important because this crime site involves several different places at which prisoners were detained. The two witnesses we've heard already were detained at the sector office as part of a group of 80 people that were arrested during a certain purge. The allegations for this site, though, also include a much larger prison that was the regularly used security office for the center. And the deceased witness, the witness we had proposed, who was a former detainee from that security office, is deceased. The other witness who had been identified and interviewed by OCIJ, who had been detained at the larger security office, is deceased. Fortunately, we started looking at the civil parties. A number of them were deceased. We were informed by the lead co-lawyers that there is only one surviving civil party from that group, 1 out of 5, and that is the person that we've now proposed, who I think you've now assigned pseudonym T2 TCP 1016. This person is also is a former Division 920 soldier. There is testimony that this security office was frequently used for the detention of purged Division 920 soldiers. The other substitution we proposed is a sister of a witness that the trial chamber is considering or has decided to recall. And we proposed, in the process of going through all the witnesses at the site, it seemed that the sister may be able to be maybe more informative than the brother who had worked at the sector telegram office. We set forth the reasons for that in our motion. She was 8 years or 5 or 8 years older than her brother, and in addition, she took on a position in the sector military in 1977. It was the sector military that had responsibility for the Phnom Penh security office. So for those reasons, because of this kind of unique situation of half of our proposed witnesses being deceased, we have proposed these two substitute witnesses.
President, thank you. And Judge Laverne, you have the floor.
Oui, merci, Monsieur.
Thank you, Mr. President. I would like the co-prosecutor to clarify something to be sure that I've understood you correctly. The two witnesses whom you are requesting to be called, are they civil parties? Because I see one is 2 TCW and another 2 TCCP. Is there any civil party among these witnesses?
One of them is a civil party, the one who is the surviving detainee from the prison. The other is a witness who worked at was the daughter of the sector secretary and worked at the sector office.
I'd like now to give the floor to the lead co-lawyers for civil parties to make an oral remark, response to the request by the co-prosecutor. You may proceed. Good morning, Mr. President. Good morning, Your Honors. Good morning, parties, and good morning, everyone in and around the courtroom. The lead co-lawyers do not object to the motion filed by the co-prosecutors, since the two witnesses have information in relation to the security center in Koh Nye and in particular in relation to that particular civil party, we met him yesterday and he confirms that he could testify. President, thank you. And I'd like now to hand the floor to the co-defense teams. First, to the defense team for Nunjir to make an oral observation or response to the request by the co-prosecutors. You may proceed.
Thank you, Mr. President. Good morning, Your Honors. Good morning, Council. We'll be brief. In principle, we have no objection to the request from the prosecution. However, I do note that in the written request, in paragraph 4, it says that the co-prosecutors request to TCW 2017 either in lieu or in addition to her brother. Now I only hear the word substitute witness. We believe that it is interest of the defense to have her brother still coming as a witness. I know he has testified before, but we have quite a few additional questions that we would like to put to him. So I'm not quite sure why it's changing now to substitute, and in paragraph 4 it is suggested either instead of or next to. We believe it's necessary to have both brother and sister come to the courtroom and testify. My second remark is an observation and is in itself independent from this particular request. I would like to inform the Chamber that we are also in the preparing phase of a Rule 87 request requesting one additional witness relating to the Phnom Kro Security Center. It's almost done. We would be happy to send a courtesy copy sometime during the day. Maybe it's something that the Chamber would like to decide on at the same time. If not, then we'll just file the request and then we'll deal with it at a later stage. Thank you.
Merci, Monsieur le Président.
Thank you, Mr. President. Good morning. Good morning, everyone. We, the Kyo Sampan Defense Team, see this as something completely new. We object to the principle underpinning this 87 paragraph 4 application for the calling of two new witnesses for two reasons. I would like to start by making some general remarks on the tardy nature of this application. The International Co-Prosecutor tells us that in the wake of the decisions, the Chamber's decision of the 25th of February 2016, they reviewed materials on Phnom Kro and the agenda and the timing of the co-prosecutor's application is not harmless. On the 5th of February 2015, that was when they mentioned it, and it's only on the 16th of March 2016 that this application is being made. This application is being made at a time when the segment on Phnom Kro has already started. Since on the 2nd, 3rd, and 7th of March, the two last witnesses were heard. And if I were to focus on this sequence of events, we would see that this is not the first time that the co-prosecutors are making an application in the middle of a trial segment. That is to say that witnesses have already appeared. And we, the Kyo Sampan's defense team, view this as an attempt by the co-prosecutors to adjust what has been said during the proceedings. If the fact that the death of the witnesses had died was the central point in the application for these two witnesses to be called, they should have made that application before the beginning of the segment, and they didn't even do that. Let me remind the Chamber that this also happened with regard to the treatment of the charm. A new application for the appearance of witness E376 was filed at the same time when we were dealing with the Vietnamese. Another application, E382 and E381, witnesses were also called. Why do I say this? We have already said this before the Chamber. The principle of 87 paragraph 4 is exceptional. When you want to use it, you must call witnesses who are not identified before or who have new particularly relevant information to provide, which was not available in the past or before then. This is not the case. Again, on the 5th of February 2016, the prosecution knew who the witnesses who had to appear were. And we wouldn't like this approach of calling witnesses in the middle of a segment to become a habit, because that poses real practical problems to us, the defense, in terms of our preparations. We have the example before us today. We have a co-prosecutor who will respond to an application, another co-prosecutor who will examine the witness, and we, the defense, are the same. We have to make applications and respond to applications. And we are ill at ease when it comes to examining or cross-examining witnesses. So to call witnesses in the last minute during a segment is a practice that must stop. It poses problems of preparation, it poses problems of equality of arms, and we cannot prepare for the calling of these witnesses in the middle of the segment. We have 4 weeks from the time when we are told who the witnesses who would appear to testify with regard to a segment will be called, and the time when they actually appear. So there are disruptions in planning and scheduling independent of the Chamber in regard to the deposition of the witnesses. So these 87 paragraph 4 applications pose serious preparation problems for us. And we can take the example of a witness in Young. We are told that very important witnesses will appear, and then later on we do not really understand exactly why the witness was called. So I want to focus on this point, all the more so as we observe that recently Rule 87.4 applications made by the co-prosecutors are systematically granted by the Chamber, bearing in mind that quite obviously this is evidence that is a priori prosecution evidence, and we have made applications for several witnesses to be called, and the Chamber has not yet ruled on them, whereas we have witnesses who can testify on several segments. Why not call them? And they may have things to say regarding segments relating to the charm and the Vietnamese. But unfortunately, we observe that a priori, and this has been the case with regard to the last expert, the Chamber only seems to accept witnesses who can be considered a priori as prosecution witnesses. Now, regarding the new witness and civil party that is co-prosecutors would like to call to appear before this Chamber, as regards the first, that is the witness, I didn't properly note the pseudonym. I think it's 2 TCW 1017. And we have the other witness. I do not quite understand in reading the WRIs why those witnesses would have any particularly relevant information on the Trump Crown Security Center. That witness didn't work at that center. If I read the WRI properly, I see that he only worked there when it was a sector office in 1974. And he worked in a female battalion that has nothing to do with Trump Crown. So he doesn't really have much to say on the security center per se. Furthermore, she doesn't talk about purges, or she doesn't talk about Cham or Vietnamese in her statements. So we do not see how her testimony will enlighten the chamber on the Trump Crown Security Center and events at that center. Since she didn't work there, as far as we are concerned, it would be a waste of time to take that witness's deposition. And I want to focus on the fact that it is not because the co-prosecutors are not satisfied with the evidence heard so far that we should prolong the proceedings indefinitely in the hope of obtaining further prosecution evidence. In so doing, calling new witnesses whose relevance is not obvious. So I do not see, based on the statements of those witnesses, anything that would be useful for the manifestation of the truth. As far as the civil party is concerned, we have a former ex-soldier of a division, and as part of that civil party's statement or application, we find that it's not complete, and the mention of the Trump Crown Security Center is not mentioned in that application, that civil party application. So I do not see how that civil party's evidence will enlighten the chamber pursuant to Rule 87.4, and that rule states that there should be exceptional reasons for calling that person to give evidence that wasn't available before. And there is no specific link between what the new witness and the civil party it would be, how it is related to this segment. So I don't see how they should replace the deceased witnesses with these two. So as the chamber had envisaged, this will not provide any additional evidence that would enable the chamber, enlighten the chamber. So it is an attempt by the prosecution to continually prolong the proceedings. So may we request the chamber to reject that application, because the segment has already started and the application is rather tardy.
President, thank you. And lastly, the floor is now given to the co-prosecutors to submit their reply to the responses of the defense teams. You have the floor now.
Thank you, Mr. President. First, in response to the comments of the Noon Chia team, let me clarify, when I say we propose these as substitutes, we're talking about substitutes for the people who were deceased. It remains our position that in the case of the sister, she could be called in lieu or in addition to. We have no objection to the brother also being called if one of the parties or the trial chamber wishes to hear from him. So I want to make clear that our position remains the same. We're proposing these people in substitution of people who are deceased, and we have no objection if the trial chamber wishes to hear both the brother and the sister. In response to the Q Sampan team's arguments, I think that to suggest that the motion is tardy because it took us a month to go back through the file. This is a complicated sector when you read the witness interviews to get your hands around which detainees came from which security offices. I can tell you it takes a little while when you're reacquainting yourself. I'd also point out that in respect to the point that this segment has already started, the only reason this segment has already started was because the first two witnesses were moved up. They were moved up because, in part, the Q-Sampan team requested a delay in completing the hearings of expert Isa Osman, also because of some health problems with some other witnesses. But we are still finishing the Cham segment, the testimony of Isa Osman. We are still finishing the witnesses from Okan Sang. The only reason we heard the Phnom Kroll witnesses when we did was because of kind of unique situation again of adjusting schedules. So I don't think it's fair at all to say this motion is tardy. This is not an attempt to adjust, it's a response to an obvious problem, which is that half of the witnesses we proposed are deceased. The defense itself, in response to this position that only the co-prosecutors are making requests, 87-4 requests, and you're only considering that, that's completely false. The Noon Chea team has made a number of requests during segments which have been granted. We've frequently received motions from both the Q-Sampan and Noon Chea team days before witnesses are to testify, experts, proposing additional 87-4 motions. We've been asked to respond to those in court the next day, which we're happy to do. This is a trial. There are situations where we need to move expeditiously. So I think it's unfair again to suggest that somehow only the prosecutors are filing these motions to supplement the evidence and that the trial chamber is somehow only considering our motions. Last, in response to the specific points made about these two witnesses by the Q-Sampan team, the prison at which the civil party 2TCCP 1016 is clearly the Phnom Kroll security office. It's described in his civil party application as a security center near a mountain in Konek district. That's Phnom Kroll. It's the only security office next to a mountain. It's the only place also where Division 920 soldiers were detained. So there's no question that this person is relevant to this segment. And again, with respect to the sister, it's clear this witness has relevant information. The trial chamber itself has selected her brother, whose knowledge is principally relates to the sector's oversight of these security offices. The witness herself didn't work inside the prison, but all of these locations, these sector offices, were within a kilometer of each other. So the people who were at these sector offices have knowledge about the security operations. Her interviews indicate that. So she would provide information about the security offices, the sector's oversight, and instructions from the center because she worked at the telegram office for a period. So that's the reason for her relevance. Thank you, Your Honors.
Merci, Monsieur.
Thank you, Mr. President. Two points in response. Yes, it's true. In the Q-Sampan and Noon Chea defense teams, of course, there were 87.4 requests that were made, but simply each time in reaction to 87.4 requests from the co-prosecution. So we cannot be criticized for looking for new elements when new witnesses arrive and we didn't have another way of anticipating the appearance of these new witnesses. Now, concerning the civil party, I don't here again see the reference made to the security center. The only clear name here is Olpeu, but we do not see Plum Kraul in the civil party's statement. Now, regarding the rest, of course, I will rely on my last observations, but please do not criticize me for reacting to 87.4 applications. Yes, of course, when we introduce new elements, there is, of course, a chance that the defense is also going to have to look for new elements in response.
President, Mr. Co-Prosecutor, do you want to address your last observation? If not, the hearing of submissions of the co-prosecutor's request and responses, as well as the reply to hear 2 TCP 1006 and 2 TCW 1017 and 16, rather, in replacement of other witness in relation to Phnom Crown Security Office has now come to an end. The Chamber is grateful to your submissions and responses as well as the replies, and this can form the basis for the Chamber to issue the decision in due course. Before we proceed to hear these witnesses in relation to that fact, now the Chamber start to hear 2 TCW 900 from Bonte Minjay via video link. From Odom Minjay, rather. And since this witness is heard by the investigating judges in other cases, the Chamber has informed party already in its memorandum, document E29/47, E29/478/2, and this witness is in the group A among the 3 groups. So please refer to document E319/35, and the Chamber requests that we should use the pseudonym in order to protect the integrity and confidentiality of the investigation and also the security of the witness. The Chamber considers that this is an appropriate measure and is in accordance with the legal provisions. This can also ensure the integrity and publicity as well as the confidentiality of the investigation. So the Chamber again reminds parties to adhere to the instruction as indicated in document E319/7. Good morning, Mr. Nyam Somnang, the staff from West Sud. You are now coordinating this process via video link. Are you ready now? Good morning, Mr. President. We are now ready, and we are here together with the Duty Council. President, thank you, Mr. Somnang. Mr. Witness, in the proceedings before the trial chamber and on the request of the co-investigating judges, the Chamber will use your pseudonym 2 TCW 900, and party will also use your pseudonym or Mr. Witness. So please be informed that the Chamber will not allow parties to use your surname and first name within these proceedings. Mr. Witness, now the Chamber would like to verify it and would like you to confirm your identity in document E3/5605 Eon in Khmer 0048 41 43 English 0048 8704 and French 0048 8704. Mr. Momdatir, the Duty Counsel, please hand over that page of document E3/5605 which the greffier has prepared to the witness for examination. Particularly, please instruct the witness to read the highlighted points in relation to his name, birth of place, date of birth, occupation, and current address, as well as names of parents and his wife. President, have you already examined that page of documents? And the information indicated in that page of document relates your name, place of birth, date of birth, nationality, occupation, names of your parents and your wife, and also your current address. Is that information true, or is there anything incorrect in that document? Witness. Good morning, Mr. President. I have examined the information in that page of document. So my names together with other information is correct. President, thank you. Mr. Witness, to the best of your knowledge and also in the report of the greffier, you have no relationship by blood or by law to any of the two accused, Nuon Chi and Khieu Samphan, or to any of the civil parties admitted in this case. Is that report correct? Answer, yes, that is correct. President, thank you. The greffier also made a report that you took a note in accordance with your religion via video link as well from your location. Is that report also correct? And have you already taken a note? Winner, yes, I have already taken note, and it is true what is stated in that report. President, thank you, Mr. Witness. I am now informing of your rights and obligations as a witness before the chamber. Your rights. As a witness in the proceedings before the chamber, you may refuse to respond to any question or to make any comment which may incriminate you. Your right against self-incrimination. Your obligations. As a witness in the proceedings before the chamber, you must respond to any questions by the bench or relevant parties except where your response or comments to those questions may incriminate you, as the chamber has just informed you of your rights and as a witness. As a witness, you must tell the truth that you have known, heard, seen, remembered, experienced, or observed directly about an event or occurrence relevant to the questions that the bench or parties pose to you. Do you understand the rights and obligations as a witness before the chamber? Witness. I have read the document mentioning about rights and obligation, and I agreed to it. President, thank you, Mr. Witness. Have you ever provided interviews to the investigating judges, and if so, how many times did they take place? Witness, yes, I gave interviews. To my recollection, I gave interviews 3 times, and most of them took place in the provincial town of Odor Mienche, to my recollection. President, before you appear before this chamber, have you read and reviewed those interviews, written records of interview to refresh your memory? Witness, yes, I have read all the written records of interviews that I provided to the interviewers. President, thank you very much. To your recollection and to your best knowledge, do the written records of the interview you provided the previous time correspond or consistent with what you told the investigators 3 times, as you said? Answer, I read the information in those documents. I agreed, and I observed that there are some points is overstated, and there are some points that I did not make a mention at the time because of my memory, but I, in fact, indeed have read those written records of interview. President, thank you very much. And as the chamber has informed already, there is a duty counsel during the proceedings, Mr. Mom Ratia. And Mom Ratia is sitting close to the witness, so it is normal in these proceedings, and this duty counsel may assist the witness during the time that there are questions which may incriminate the witness. In accordance with the internal rule 91 bis of the ECCC, the floor is first given to the co-prosecutors before other parties. The combined time for co-prosecutors and lead co-lawyers for civil parties is 1 day. You have the floor first, Mr. Co-Prosecutor.
Thank you, Mr. President, and good morning to your honors. Good morning to all parties. Good morning to the public. Good morning, witness. T2CW 900. I am going to spend a good part of this day putting questions to you. Given that we are speaking through video link, I will try to speak slowly so that so that my questions are understandable. I first of all would like to ask you one or two questions on the period that preceded 17 April 1975. So I'm speaking here between 1970 and 1975. So can you tell us very briefly when you joined the revolutionary forces, and who was your direct superior then?
Answer. From 1970 to 1975, I was a soldier, and I became a soldier in 1971. First, I was in Regiment 39, and the commander, my commander, in that regiment the commanders in this regiment mostly came from Hanoi. They were cadres from Hanoi, and I could recall their names, Tajane and Tasan, and as of now I do not know where they are living. So again, I became a soldier between 1970 to 1975.
Thank you. Do not worry if there's a gap between the moment when you answer and the next question. It's because what you're saying in Khmer is first interpreted into English and then into French, so it might take a bit of time. So, at one point in time, was your regiment 39 incorporated into a division, and what was the number of that division and who led that division?
Answer. Previously, Regiment 39 was under the central. It did not belong to any other divisions. And our headquarters was close to Phnom Santuk or Santuk Mountain in Kampong Thom province. And at that time, we were engaged in Jinla 2 battle. So soldiers were mobilized to be stationed around the Kampong Thom province. And we conducted operation in locations close to Santuk Mountain in Kampong Thom province.
Fine. And later on, did you join Regiment 82? And what was your function in that regiment?
Answer. Later on, Regiment 39 was sent to be stationed in the northwest of Phnom Penh. First, we were stationed in Palhal, west to Prasit Mountain. In relation to Regiment 82, it was under Division 801. But before Division 801 had its name. In fact, that Division 801 used that number after the liberation. And during that period, the Regiment 81 and 82 was under another division. That is Division 14.
Fine. So who was the leader of Division 14 before it became Division 801?
Answer. After we were stationed in Phnom Penh, west to Phnom Penh, San was the commander of Division 14. When we started to to be engaged in battlefield 909, the commander in charge was So Sarun. He was from the south, and he came to be part of Division 14. And at the time, we were engaged in the battlefield 990 in the northwest of Po Chun Tong.
Thank you. Now I'm going to be speaking about the period that followed the capture of Phnom Penh in April 1975, and I'll try to speed up a little bit. What was the role of your Division 14 after the capture of Phnom Penh? And where was this division posted?
Answer. After the liberation of 17 April 1975, the Division 14 was posted and conducted operation to protect Phnom Penh from the location between railway station to the west, close to Po Chantong, there is Khmuing or Prayap. And the headquarters of that division was in Olympic Stadium.
Alors, deux questions à ce propos.
I have two follow-up questions. You have referred to the railway station. After the liberation of Phnom Penh, did you attend or were you aware of the fact that there were meetings of the leadership of the revolution who met at the railway station?
I was not aware of the location of that meeting.
Votre division.
The headquarters of your division was the Olympic Stadium. Was your division also in charge of providing for safety during major rallies held at the Olympic Stadium in 1975?
There was a meeting held at the Olympic Stadium. However, at that time I was not there. I was somewhere in Khmuing or Prayap, since I was assigned by the divisional commander to erect a radio communication post. And I actually went to the stadium at night time to watch a performance, but I was not allowed in.
Pour autant, je voudrais lire ce que vous avez.
Yet, you said something, and I'll read out what you said in E3/9734. In answer number 2, you stated that after 1975, I met Sumet when he attended a meeting at the Olympic Stadium. At the time, I was in charge of radio communications of Division 14, headed by Sasarun, which became Division 801 subsequently. Son Sen came regularly to attend meetings in Sarun's office. Did you attend any rallies at the Olympic Stadium, and if so, can you give us any details on that rally?
Well, I worked at the office of Division 801, which was a new name for Division 14. I never attended a rally held at Olympic Stadium, nor did I attend any meeting held within the vicinity of the Olympic Stadium. At that time, I was a radio operator. and my role was to set up the chairs and the tables and the drinking water. But personally, I did not attend any meeting there, although I knew there were representatives from other divisions to attend meetings. And my role was to set up this logistical support for the meeting only.
Est-ce que vous vous souvenez du moment
Do you recall when Division 14 was renamed as Center Division 801? And after, when was that? During the period after the 17th of April 1975?
To my recollection, the redesignation of number to Division 801 was made before it was deployed to Ratanakiri province. And that could happen in around October or November. At that time, the weather was pretty cool.
quand vous parlez d'octobre ou de novembre 60?
You talk of October or November 1975. At that time, had you already been posted to Ratanakiri to work in the new Division 801, or it was well after that?
After I learned that the Division 14 was renamed to Division 801, troops within the division were prepared to be sent to Ratanakiri province. Initially, there were only certain number of troops who were sent to the province from the headquarters. And at that time, we took along the radio, which were the war spoiled from the United States products, and actually, its range was communicable with between Ratanakiri province and Phnom Penh, and also it could be extended to other units. I was one of the first soldier who was sent there with a Tasan, and I resided in Risaicha in Kathi province when I was first deployed to that location.
Parmi les tâches qui étaient
Among the tasks assigned to Division 801 in the Northwest, did that division have to guard particularly the border with Vietnam?
The division was assigned to be stationed along the border area, that is the border between the three countries, that is Laos, Vietnam, and Cambodia, and also at National Road number 19 in the area of O Yadao.
En deux mots, quel était
In a word, between 1975 and late 1975, when you arrived there, and 1979, who was the member of the Northwest Zone Committee initially, since the divisions of the Northwest Zone changed as time went on?
did not know the changes within the northeast zone, says the witness. I only know the changes within Division 801. There were regiments subordinate to Division 801, which were stationed in various locations, including Siangpan. And there was another regiment stationed at the border area, as I mentioned earlier. And there was also another regiment stationed in Bokeo, that is to protect the border area and along the upper part of Sesan River. And so that road is now called O Yiu Ming.
D'accord.
Very well. Let me return to the previous question. Who was the chief of the Northwest Zone when you were there? And perhaps I can press on to ask you where the office of the Northwest Zone was situated.
I did not know the office of the Northeast Zone. However, I was first stationed in Ban Lung. That is a little bit to the south of Swai Mountain, and that was a former Lon military barrack. And I saw many empty shells and some unexploded shells. There was also an office near Konsai, and that office was known as the sector's office, although I myself did not go to that office. So let me repeat, I did not know where the office of the Northeast Zone located. President, thank you, Deputy Co-Prosecutor, and thank you, Mr. Witness. It is now convenient for our short break, and Mr. Witness and Duty Counsel, you may also have a break from now until 10:30 when we resume. So please return to where you are before 10:30. The chamber will take a short break and resume at 10:30 this morning. The court is now in recess.